Announcement of judgment, item number 23.
The criminal appeal is dismissed.
May I please, your lordship? I beg to mention item number 22, lordship.
Item number?
Item number 22, lordship. But with the
22.
concern of the other side, I beg to mention for adjourn, lordship.
You are for the appellant?
Appellant, lordship. I am appearing on behalf of SG Borua, B Borgunhai, lordship.
Your name?
B Borgunhai, lordship.
Okay. Mr. B. Boruhai, learned counsel. Appearing on behalf of MS SG Borua, learned counsel for the appellant, has paid for an adjournment.
It's a matter may be fixed after vacation, lordship.
MS B. Bora, B. Bhuya, learned senior counsel and additional public prosecutor, but the respondent number 1, state of Assam, is present. Any respondent number 2, inform
Inform, lordship. We have taken the consent, lordship.
and has submitted that there is no objection from our end. It is submitted that consent has been taken from the respondent number 2 to make the appeal. As sought for is the case after appeals after 2 weeks.
It's after vacation, lordship.
It will automatically go up after
Much obliged.
on a date to be by the office.
Right, your lordship. Lordship, I beg to mention item number 20 for adjournment, your lordship. Lordship, Mr. S.K. Talukdar met an accident last night, my lord.
Okay.
Minor
MS
accident.
SK Bok.
ST Bok, your lordship.
ST
Bok.
ST. Bok, learned counsel appearing on behalf of Mr. SK Talukdar, learned amicus curiae for the appellant, has submitted that Mr. Talukdar, serious,
No, madam, minor accident. Adjourn for a day, your lordship.
has made an accident yesterday and has thus sought for an adjournment. S.H. Bora, learned additional public prosecutor for the respondent state, is in attendance, who is in attendance, comma, has no objection to say here in view of the ground cited. Release the appeal after 2 weeks
Obliged, your lordship.
on a date to be by the office.
May I plead the lordship? Lordship, I beg to mention on IA in connection with a criminal appeal. IA is for suspension of sentence and bail. The state has already filed their objection also. So may I pay for listing it on 20th?
The court master will fix it.
May it please your lordship. Lordship, I, with the concern of the other side, lordship, I beg to mention item number 21,
21.
lordship. That
Yes.
is,
I am for the appellant, sir.
Okay. You are for the respondent.
Appellant.
lordship.
This is what, 17 others.
Acquittal.
Lordship.
Your name?
So we use here on behalf of S.A. Borua, lordship.
Okay.
See, my seat.
Mr. J.C. Bora, learned counsel for the appellant, and M.S.B. Bhuyan, learned additional public prosecutor for the respondent state. Respondent number 1 state are present. Mr. U. Boruhai. U. Soikia, learned counsel. On behalf of Mr. A.C. Barbara, learned senior counsel for the respondent number
2 to 18,
17. 2 to 18 is
2 to 18, lordship.
has sought for an adjournment.
Lordship, let it be taken after vacation.
On the part of Mr. Barbara. Yes.
Lordship, let it be taken after vacation.
My lord, can it be before
No fixed
vacation?
date.
Because it's a 20,
No
20,
fixed date.
20 meter, man.
Release the case after 3 weeks on a date to be fixed.
May I pray for date, man. Then.
It is hearing.
Yes, man.
Registry will fix the date.
Yes.
It is for episode item number 1.
May I please, lordship? This is J.
Or legal aid counsel.
Lordship.
Heard. MSD Board, Ujari Learned Legal Aid Counsel for the appellant, and MSD Via Learned Senior Counsel and Additional Public Prosecutor, assisted by MS Ardas Learned Counsel for the respondent. State. Will appeal under section 372, 74(2) Code of Criminal Procedure 1973 is preferred against the judgment and order dated 11/10/2023, passed by the Learned Session Judge Kamrup Amingao in Sessions Case number 17/2022, by the judgment and order dated 11/10/2023, the accused appellant has been convicted for the offense under section 302 Indian Penal Code, and he has been sentenced to undergo life imprisonment and to pay a fine of rupees 5,000, in default of payment of fine, to undergo further simple imprisonment for further 3 months. So, appeal is admitted for hearing. The case records of Sessions Case number 17/2022 be called for. Issue notice returnable in 4 weeks as MS Puya Learned Additional Public Prosecutor has appeared and accepted notice. Issuance of formal notice is dispensed with. Extra copy. Memo paper. 3 opinions.
States by registered post.
No
302.
respondent.
302.
No respondent to you too,
Okay.
so we are not issuing any.
My law.
You will represent.
My
Complaint, Lordship.
It please your lordship. It is appeal from jail lordship. The appellant was convicted under section 6 of the
Learned. Counsel for the accused appellant. NMS B. Learned additional senior counsel, additional so assisted by so. This criminal appeal under section 374 is directed against a judgment.
I come to prosecute.
And-
It's good. Ajina Belagi.
Judgment
Oh. Oh.
10/1/2000. Passed by Learned Session Judge Sipsagar. In sessions, in case number sessions 136 within bracket S of 2016 by the judgment and order date so and so, the accused appellant along with 3 others has been convicted for the offenses under section 302 Indian Penal Code and section 323, IPC in aid of section 34 IPC. The accused appellant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000 with default stipulation, for the offense under section 302 IPC read with section 34 IPC, for the offense under section 323 IPC. Oh no, not nalage, it would nalage. Foreign foreign okay, this Borun, he is Borun man. Okay, I got liver. A offenses nalage, offense under section 302. A 323 part 2 value. Appeal is admitted for hearing. The case records of sessions case number so and so we call for. Issue notice returnable in so and so. We Bhuya, as Bhuya appeared accept notice. The accused appellant shall take steps for service of notice upon the respond number 2 informant by registered post with AD, as well as by usual process within 3 working days from today.
There is an IM also.
IA,
Notice
We
may
file our objection.
I had to lick it, very well. 389, hard MS P Bora, P Bhuiyan, 389. Baki okay, issue notice.
Out of,
Copy of the IA is not available. I have
No, sir,
asked.
I will
for
find it.
Copy of IA is not available.
Okay.
I will find it.
MS Bora, learned counsel for the applicant appellant, shall furnish a copy of the interlocutory application to MS P Bhuiyan within 3 working days from today.
Not sir, out of same judgment,
Objection also, objection liquidity.
out of same judgment, another appeal is pending before its honorable court. It may be tagged with this appealment. Appeal
There,
number-
let it, returnable date.
Lord-
Returnable date, you
Lordship.
make it.
Lordship, steps may not be required. She has made party respondent.
We have issued notice parties,
Yes, okay.
register post,
My lord,
Lordship.
not by 2PP.
my.
Supplementary list item number 24.
Wants to come, you can come.
My lord.
May it please your lordship. Lordship, I may be allowed to approach the learned special judge, lordship.
Heard Mr. P. Borolo, learned counsel for the appellant, and Mr. R.K. Devchudri, learned deputy solicitor general of India for the respondent, and I. So, Mr. Borolo, learned counsel for the appellant has submitted that as the charge sheet has been
Lordship.
submitted in the meantime, the appellant wants to prefer, wants to approach the learned trial court afresh in such view of the matter, he, the appellant does not want to press this appeal.
Lordship.
So, in view of the above submission made by Mr. Bordole, learned counsel for the appellant, this appeal stands dismissed as not pressed.
Lordship. I may be allowed to approve.
You have some, your submission is recorded.
Lordship. Oblige your lordship.
For orders, item number 4.
Objection filed.
This, issue notice হয়ে আছে একো আহা নাই পেপার বুকও দিয়ে দিলাম Heard Mr. R. Dave, learned legal counsel for the appellant, and MS B. Bhuiyan, learned senior counsel and additional public prosecutor, assisted by MS R. Das, learned counsel for the respondent, number 1 state of Assam. As the records from the learned trial court, case records from the learned trial court have been received from our office to prepare the paper book first up. In view of the office note dated 11/6/2024, let the case be placed also before the Lojipa court in order to ascertain the service of notice upon the respondent number 2 and to submit a report in that connection. Please the case after 4 weeks.
7.
May it please your lordship. Today the case has been listed for consideration of IA number 958 for suspension of sentence. Lordship. Here in this case, lordship, the PWs are in vernacular language, lordship. And the ground which
We have no difficulty.
Even I have no difficulty.
You have difficulty.
No. Punasu, objection filed is in.
Conviction is under
under 302, lordship, for life.
302. Any direct evidence?
Direct evidence, lordship, there is, in this case, there is no eyewitness, lordship. The incident occurred inside the house, and here in the father was convicted for the murder of his own son, lordship. There are as many as 11 numbers of witnesses, lordship. Here, 1 and 2 were only present at the time of incident, lordship, in the house.
Let us see the FIR. Have you annexed the FIR?
I have not annexed, lordship.
Not annexed.
Perhaps the case will come under 304 part 2, lordship. not a case of murder, Lordship.
What is the period of detention?
4 years, 7 months, today 4 days, as on
And
today.
on that count also. Sodium more shiny. Microphone দেওয়ার আছে। ভারতীয় Your son
Yes,
and your son, sister-in-law. Sister-in-law PW1
PW1 is a sister-in-law.
and son
PW2
is
is own
PW2.
son, yes.
Very specific,
Lordship,
very specific and categorical. No cross-examination.
although they were present, but PW2 followed,
What more is required? Two sons when inside the room,
yes,
that PW2 came out. The dispute was regarding his daughter, 2 years daughter. He came out thus thereafter.
but both were,
What more is required? To consider at least the application under section 389.
yes, sir, that is not so palpable to,
Without going to detail merits.
yes, sir. Pharma physician satisfied the code. Yes, sir. That's true, but case will perhaps will fall under,
Even though on that counts, severity, what is the
but
exhibit PM report? Exhibit. Whether knowledge, intention sufficient to cause death in the ordinary course, that can be gone into in the appeal. This is not the stage. Exhibit.
exhibit P2. P2. In my opinion, the cause of death of the deceased is due to coma arising out
P2,
of
one minute,
sustained
P2.
injury on the spinal cord.
P2. Seizure is one down.
There is one down.
Spinal cord. 6 inches long, deep, sharp cut.
Injury.
Inches long the sharp that present on the posterior aspect of knee. Training comes with those. Take body again.
In fact, deposition of PW7, the the evidence of the doctor is
What?
shows
What
the
does he say?
injury. PW7
What does he say?
regarding injury, Lordship.
Huh.
During examination, I found 6-inch long deep sharp cut on the posterior aspect on the
That I
neck.
have already read. Mr. Halder, at this stage, I don't think it is there is merit. Heard Mr. B. Halder, Learned Legal Aid Counsel for the accused applicant appellant, and MSB William Learned Senior Counsel and Additional Public Prosecutor, assisted by MS Ardas, Learned Counsel for the opposite party number 1, State of Assam. Post of the instant application under section 389(1), Code of Criminal Procedure 1973 is preferred, seeking suspension of the execution, suspension of execution of the sentence passed against the appellant in sessions within bracket CHA bracket close case number 15 of 2020. By the judgment and order dated 29/5/2023 rendered in sessions within bracket CHA case number 15 of 2020, the accused applicant appellant has been convicted for a charge of murder under section 302, IPC, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for another 6 months under section 30, another 6 months. Full stop. Para. The applicant as the appellant has preferred the connected criminal appeal, criminal appeal within bracket J number 112/2023. Full stop. Para. Learned Counsel for the Learned Legal Aid Counsel has submitted that there is no direct evidence in that there was no eyewitness who had seen the actual assault. Full stop. He has further submitted that there was only one injury on the person of the deceased. Opposing the application, MS Bhuyan, Learned Additional Public Prosecutor, has submitted that the severity of the blow was such that it was sufficient in the ordinary course, sufficient to cause death on a person. On the issue of direct evidence, MS Bhuyan has contended that the testimonies of PW1 and PW2 were categorical and consistent in that they were present in the close vicinity of the place of occurrence. First of, we have considered the submissions of the learned counsel for the parties, and we have also gone through the materials available in the Yes, records of sessions, case number so and so in original for the purpose of consideration of this application. The testing the PW one is the daughter-in-law of the applicant appellant and the sister-in-law of the deceased. So the PW2 is a son of the applicant appellant and a brother of the deceased. Full stop. Both PW1 and PW2 are equally related to the accused and the deceased. Full stop. Evidence on record are prima facie suggestive of the fact that the PW1 and PW2 at the time of occurrence, were in the close vicinity uh, of the place of occurrence. So they were in the same campus when the alleged assault was made on the deceased by the accused inside a room of their house. So the testimonies of PW1 and PW2 were to the fact that they saw the disease coming out of the room with a deep cut injury on his neck. So the accused was the only inmate of the room where from the disease had come out. So the postmortem examination report, exhibited as
P2.
P2 and the testimony of the autopsy doctor who was examined as PW7, had deposed that the deceased sustained a 6 inches long, deep, sharp cut on the posterior aspect of neck, extending from C2 level to the mid portion of occipital
Medical terms.
bone. So, as per the opinion of the autopsy doctor, the cause of death of the disease was due to arising out of the injury sustained on the spinal cord. So, having regard to the above materials, above evidence record, we are of the privacy view that the present one is not a fit case for extending the benefit under section 389 CRPC, 389 within bracket 1 CRPC. Post of resultantly, the instant application is dismissed. Post of it is however clarified that any observation made herein shall not be construed as observations on the merits of the pending appeal. appeal, main appeal to revision paper book.
Not ready yet.
And your paper book order to read them. Main appeal. 302 no required. Private respondent not required.
May not be required.
Heard Mr. P. Halder, learned legal aid counsel for the appellant, and MSB Bhuyan, learned senior counsel and additional public prosecutor for the respondent state, full stop. As the records from the learned trial court, records from the trial court have been received from our office to prepare the paper, full stop. List the appeal after 4 weeks.
All right.
Number 8.
Yeah, please, Your Worship. The conviction under POSCO.
Hmm?
The paper book.
Number 9.
Yeah, please, Your Worship. Lordship, as per the instruction received, Lordship, by me, that surgery will be done, Lordship, on 10th of July, Lordship. Some date has been given to him.
Yes, Ramesh. Yeah.
Received. One copy you have received through process server, that alog, na? Different to them. Okay, forwarding from.
Police is chronic.
Okay, no, forwarding for na, আমার এখন। তাহলে হবে।
Evaluation a clinical surgical degree, laptop to different policies like blood pressure. Past study is okay, past study is okay, chest, air and sleep. They are planning surgical operation, laparoscopic or open cholecystectomy.
Tommy.
Yes, Lordship.
Your blood pressure is quite okay, 140/84. Pulse rate 72, oxygen 99%. Other parameters are okay. Go through it.
এখন রিপোর্ট দিলা এইখানে নাই না এখানে আছে রিপোর্ট ডায়াগনস্টিক এখানে নাই
But you've been together.
Yes, Lordship.
Perfectly okay.
So he will undergo surgery, Lordship.
What better institute than GMCH?
But even then, Lordship, he should be under the care of his attendants.
Who's in the care?
Yeah.
Mhm.
What care?
Is at least his son or someone should be there. Because-
There is procedure laid down everywhere. Why should you observe?
Lordship,
Go through the prison manual and all these acts. Why you have to observe?
No, I am not praying for observation, Lordship, but this 389 petition, Lordship. I'm praying for consideration of the 389 petition in
Show
respect.
me any ground,
Yes, Lordship.
what ground?
Ground, Lordship, here.
On merit only,
Yes, on
not on health.
not on health, Lordship. Here, Lordship,
Offense.
offense is 302, Lordship,
Paperbook ready.
and 34.
Then paperbook is to be made ready then. What is the
Paper
status?
book is ready, Lordship.
Paperbook is ready? Good.
Paperwork is ready.
Office to college, sir. Engineer two. Dispense করবো পারে।
Let us see the FIR first.
Yes, Lordship. Lordship, may come
What
to
is palpable? Apparent on the face of the record. This is the yardstick. Don't go deep into the merit.
no, Lordship.
That is the yardstick.
Yes. That is a matter in the appeal, Lordship, not here.
Apparent on the face of the record.
Yes. FIR lodged by the
What is the FIR?
FIR at page 4 of the paper book, Lordship.
Number submitted. Their morning. Company by labor. Company by labor. Ismail Ali. Abdul Masri was working in our.
PW five is the eyewitness.
Let me understand the story. Used. Who are you? All three.
Lordship,
Hasimuddin.
I'll place for only
Hasimuddin.
1 and 3, Lordship. The father and the mother, Lordship.
Huh?
All are from the same family, Lordship. Hasimuddin, Saidul, and Cypher. The pair, father, mother, and the son.
Use 1 and 2. 2 is 1 Hasimuddin, Saidul, 2. When it into a box, seeing that my father went for work. When it was good. Sorted. Accused number 1 is the father.
Father. And
2
three
is the son.
2 is the son, and
3 is the wife.
he is the wife of 1.
Let us see the nature of an assault person. What kind of injury he has sustained?
Lordship will find
PM
the
at page 73.
Page
Yes, sir.
73.
74, not injury.
injury.
Exposing spinal cord
And the opinion of the
and brain matter.
doctor is that, Lordship,
Right spheroid.
due to
bone is
brain and
fractured.
spinal cord injury, Lordship.
Rigor mortis present. So no other injury.
And lacerated injury also.
Lacerated injury on right side of brain. Spinal cord transected at upper cervical region. This shocking as a result of brain and spinal cord injury is antibiotic. What is the role attributed to each of the accused?
Lordship, may
Three,
there are
5, and 7, my lord.
3, 5, and
7.
all
they are
the
convicted in aid of 34.
yes, Lordship.
This is the labor.
No, Lordship,
PW3
no.
was the labor.
Deceased was the elder brother of this.
PW3.
3 was the
That labor.
labor of that
Okay.
deceased.
PW3 saw Saidul had a hoe in his hand. Saifar and Hasimuddin had lathis in their hands. Then subsequently, my lord, PW5 and 7, not subsequently, PW5 and 7 are the direct witnesses. There are ocular evidence be considered. Page 18, your lordship. Hasimuddin and Saifar Bhanu attacked my father with lathi.
PW?
PW5, page 18, fourth line.
Is the son of the deceased.
Son of the disease.
Yes,
That
Lordship.
is the informant.
No,
Huh?
the other son, Lordship.
Other son.
Informant was the daughter, Lordship.
Okay. Informant name?
Informant is the daughter. She was examined as PW1, Lordship.
Muksina.
Oxim.
Muksina. So far, her presence was not there.
No, Lordship.
PW5.
PW5, he said that Saidul, he struck on the head of his father with the hoe, Lordship.
Yeah, PW5, then
5 and 7.
7, Lordship.
They could not be shaken, my lord. Hasimuddin and Saifar Bhanu, no?
Saifar Bhanu, Hasimuddin,
Third line, page 22. I saw Majibur being assaulted by Hasimuddin with a hoe and Saifar Banu with branch of tree. I
he
also noticed
contradicts, Lordship,
Saidul assaulting Majibur on his head with hoe.
with the son, Lordship. Because there was only
as
one
you
hoe.
Saidul, it is consistent.
Yes, Lordship. But there was only one hoe, Lordship. Even RRD witness who has heard the incident, Lordship, they said that Saidul has,
Heart is different.
yes. They implicated Saidul only.
Their presence was not denied.
Well,
PW3, PW5, and PW7.
Seven.
Their presence at the place of occurrence was not denied. And the presence of the 3 accused is also not denied. One
That branch of tree
inconsistency
and
is that in the evidence of PW7, there were two holes. And he is otherwise an independent witness. That is not changing the core case of the prosecution. Core case to be changed on
It will 5 to 164 to consistent.
164. 164 is also consistent.
Page number 71.
71.
164 Lordship.
This is for just to
Hmm.
inspire confidence. We examined whether she came later on. They were family in arms.
They were not armed, Lordship. Actually, they suddenly,
Arms.
that
Rather,
incident
it's
took
a-
place suddenly,
I'm
Lordship.
saying the song of Mark Knopfler, Dire Straits. PW3 or PW7.
PW 5.
5 medical.
No. I think so. Hmm.
9, no?
Nine.
Lordship, the
Yes,
paperwork is not there.
Because he testified that he was also assaulted.
He was assistant.
Their presence are also there. That brings in
Well,
34.
my lord.
And these two are independent witnesses. PW3 and PW7. At this stage,
PW3, he has not seen Lordship who has assaulted, but 7,
the-
Yes,
he
That's
said that
also-
they were carrying those hoe and lathis in their hand only.
But it is a concept of res judicata is very much applicable in this case. Section 6 of the evidence. His evidence can be considered under the concept of res judicata incorporated in section 6. We do not want to observe all these evidences. But primarily it appears PW3's evidence is supporting PW5 and PW7. These three prosecution witnesses' presence are not denied. The presence of the three accused persons at the place of occurrence is not denied. Not challenged in any manner. Then PW5 is consistent 164 and before the court. The nature of injury is such that it is likely to cause death. That's what instantaneous death.
Can I,
Instantaneous death, mister. What to do? Hard.
Lordship,
Yes,
can I
sir.
pray one thing, Lordship?
Huh.
Can I pray a temporary bail for this accused number 1 till
We
his
fought,
surgery?
we tried to
No,
find
Lordship.
out whether that
Only on this
lady
medical
was.
ground, Lordship, for till his surgery.
Oh, no,
Lordship.
no. Who will look after? GMC is the best authority to look after. His wife and son, they are in
They are in jail.
detention. Who will look after? Prison then will definitely relate, presence of relative will be permitted. Why not? Go through the prison manual. And prisoners act. I think these are permitted
My lord.
at the time of surgery. Why should we observe all this?
Hmm.
We said this is perfectly okay. Medical, we have passed number of orders. Now we are deriving satisfaction that he is well taken care of. Report you have seen.
Yes.
So no further submission. We can ask for a report on the next date. But so far as merit is concerned, we are not satisfied that this application has merit. Appeal might have merit. Nothing apparent. And this application is for medical or something else on
No,
merit.
It's 506,
289.
Huh?
389 petition. 506.
389 on what ground?
Medical is not a person, okay?
No,
On
Lordship,
merit.
on
On
merit.
merit.
Because earlier he was not suffering from.
We'll close.
What is it?
We'll close this.
Nine.
Regarding medical aspect, you can file fresh application. That is one thing that to know about the present status of operation, right? But on merit, we are closing it because this application is clearly on merit. We extended the privilege because you submitted that his position is, medical condition is not good.
That was the instruction on when I
Oh.
received.
So
So I
accordingly-
filed that affidavit. Lordship.
Accordingly, we considered medical reports were called for. His condition is conducive for surgery
This is for the second time they
Oh.
have filed.
and he is likely to undergo surgery. They are taking care of heart, Mr. Rahman. Learned counsel for the applicants, and MSB and senior counsel and additional investigator for husband number one.
Medical ground. It only was for that.
Learned counsel for the parties are heard on merit in respect of the instant interlocutory application preferred under section 389 within bracket 1, Code of Criminal Procedure 1973. The applicants are undergoing sentence for the charge under section 302, Indian Penal Code. Close. Para. The applicant number 1 is the husband of the applicant number 2 and the father of the is the father of the applicant number 2 and the husband of the applicant number 3. Para analyzed. PW2 or PW3. Oh, sorry, PW5 as the informant. Sorry. The case, Dolgaon Police Station case number 45/2017 was registered for the offense under section 302, IPC, read with section 34, IPC, on institution of a first information report by the informant SPW 5 on 21/1/2017. In the said FIR, the informant PW5 naming the present 3 applicant appellant as the accused had mentioned about an incident which occurred at around 9 a.m. on 21/1/2017. The allegations in the affair were inter alia to the effect that the 3 accused persons had assaulted part of that informant as PW 5 when his father was in their garlic cultivation, which 2 laborers, PW 3 and PW 7. Mr. Roman, learned counsel for the applicant appellant has submitted that there were certain inconsistencies in the testimonies of PW3, PW5, and PW7. Opposing such contentions, MS Bhuyan, additional public prosecutor, has submitted that the testimony is of PW3, PW7, PW5, and PW7 were consistent as the material points are concerned. We have perused the testimonies of the evidence, also materials on the record, including the testimonies of PW3, PW5, and PW7 for the purpose of consideration of the prayer made in this application. We have also perused the post-mortem examination report. I exhibited as 5. And the statement of the informant PW5 recorded under section 164 CRPC. Which was exhibited as EXT. Right, EXT 4. Posted. The PME report EXT 5. Reported a cut injury on right side of face and neck, page 74, exposing spinal cord and brain matter. It had further reported that right spheroid bone was fractured. There was lacerated injury on the right side of brain and a spinal cord transected at upper cervical region. So it was opined that the date of the disease was due to shock and hemorrhage as a result of brain and spinal cord injury, and the injuries were antemortem in nature. The 3 prosecution witnesses, that's PW3, PW5, and PW7, that's the presence of the 3 prosecution witnesses, so and the place of occurrence, and at the time and place of occurrence were not contested by the defense. The prosecution witnesses PW3, PW5, and PW7 were consistent in their testimony that the applicants, the 3 accused persons were at the time and place of occurrence of the incident. First of PW 5 had specifically deposed about the manner of assault, and the testimony of PW 5 is sufficiently corroborated by PW 3 and PW 7 as regards the occurrence. First of PW 5 is found to be consistent in his, there was no departure in that, there was evidently no departure in the testimony of PW 5 given in the court from his earlier previous statements recorded under section 164 CRPC. First of আপনারা রাখতে হবে, having regard to the above evidence of materials on record and taking a prima facie view, we are of the considered view. We are of the view that the instant application under section 389 1 CRPC. No, the present one is not a present case is not a fit one to extend the benefit to the applicant's appellants under section 389 CRPC. Resultantly, instant application stands dismissed. First of the para. The MS Puya.
এটা রেখে দিল।
MSP has placed a communication bearing number so and so dated 11/6/2024, enclosing therewith a report of the communication from the superintendent, Central Jail Guwahati, enclosing therewith a report of the medical and health officer -1, Central Jail Guwahati. As per the health status report provided by the medical and health officer, Central Jail, Guwahati, in respect of the applicant number 1, who is an prisoner in Central Jail, Guwahati, he has been diagnosed as with chronic calculus cholecystitis. First one. After evaluation, after his evaluation in the surgery department of the Guwahati Medical College and Hospital, surgical operation, namely, laparoscopic stroke open cholecystectomy is being planned after evaluation. Post-op. After examining the other parameters, the medical and health officer reported favorably. The said communication dated 11/6/2024 and the report of the medical and health officer Central Jail Guwahati placed by MS Bia are kept as part of the case recording. If something more required, you file regarding health.
Lordship, one correction, Lordship, that PW5 not informant, Lordship, PW2 informant, Lordship. I heard PW5.
Informant over to Katido.
One to
Informant to
informant.
Katido.
Two.
Altogether.
One, no?
First, informant PW 2 লিখো
One,
No,
one.
my lord,
Lordship,
one.
one.
Moxina.
একদম প্রথম তাৰপিছত আৰু ইনফৰ্মেল লিখিব নালাগে
Main case we fix for hearing.
yes the main appeal heard Mr. M. Ahmed, learned counsel for the appellants and MSB Bhuiyan, learned additional public prosecutor, senior counsel in additional public prosecutor for the respondent. Itu copy ane. Okay. Let the case be placed before the Loajima court to find out the status of service of the notice sent to the respondent number 2 by registered post on 22/6/2023 and to list the case after 2 weeks with a report of the Loajima court. We'll close that service.
Well,
Thereafter we'll proceed.
Item number 10.
The respondent number 2 is no more as per the
Week
office.
2,
302 offense.
date.
As per office note dated 12/6.
Had Mr. J. Das, legal aid counsel for the applicant appellant and MS S.H. Boral and additional public prosecutor for the respondent number 1, state of Assam. The instant interlocutory application under section 5 of the limitation act 1963 is preferred, seeking condonation of delay of 87 days in preferring the accompanying appeal. Full stop. The pursuant to the order dated 10/4/2024, a report from the Chief Judicial Magistrate Nalbari has been received reporting that the respondent number 2 has expired in the meantime. The applicant as the appellant has preferred the connected appeal, accompanying appeal. It's a judgment dated 13/9/2023 and an order on sentence dated 18/9/2023 passed by the learned Sessions Judge Nalbari in Sessions case number 57/2015. By the judgment and by the state judgment and order on sentence, comma, the applicant appellant has been convicted for the offense of murder under section 302 IPC, and he has been sentenced to undergo life imprisonment and to pay a fine of rupees
10,000.
comma, which default stipulation. Full stop. The applicant has explained, applicant appellant has explained the reasons for the delay of 73 days,
Delay of
87
87
days.
days.
87 days in paragraph
4 to 10.
4 to paragraph 10 of instant application. Having gone through the statements and averments made in paragraph so and so to paragraph so and so, we are of the considered view that the applicant has been able to explain the regions showing sufficient cause regarding the delay of 87 days, comma, which has occurred in preparing the accompanying appeal. Accordingly, comma, the instant interlocutory application stands allowed to stop the register to list, register the connected appeal and list the same thereafter accordingly.
Much obligation.
Offense, madam?
Subsection 2 of POCSO Act.
Item 17.
Your lordship, appeal already admitted lordship 302 and LCR also received.
You are pressing with I.
Lordship, let the paper book be prepared. I want to press it because mainly on the ground of he is from 2011, he is behind the bar, all 13 years. And
Offense,
302.
eyewitness,
Eyewitness is there, but discrepancy is also there. He is a CRPF constable and allegation that he had sued his assistant commandant.
is there any merit in this application? We'll pass the order in appeal.
Yes,
Paper
objection
book or
already.
paper book?
Objection
paper?
already filed.
MS Sharma has submitted that the instant application be taken up after preparation of the paper. Full stop. It is observed accordingly. Heard MS B. Sharma, learned legal aid counsel for the accused appellant, and MS Mr. K.K. Das, learned additional public prosecutor for the respondent number 1 from state of Assam. As the case records of the learned trial court have been received, comma, office to prepare the paper book, release the case. Appeal after 4 weeks.
If lordship, I date in the month of at least August because long
report.
detention period.
For a report on the paper book. Then they will come with a paper book, or that we
Lordship.
need 2 more weeks time.
Item 18.
May I please, my lord? This is an interlocutory application filed for condonation of delay in a
How many
connected
days?
criminal appeal against
How many days?
9 days, my lord.
Offense?
302, my lord. The convict is serving He's the sentence in Jorhat jail.
MS
S Midi, I'm
Learned
in
Legal Counsel
My lord.
for the applicant appellant and Mr. K.K. Das, learned additional public prosecutor for the opposite party, that's respondent number 1, State of Assam. Full stop. The instant interlocutory application is filed under Section 5 of the Limitation Act 1963, seeking condonation of delay of 9 days in preferring the accompanying appeal under Section 374 2, Code of Criminal Procedure. CRPC লিখে দেবো, from CRPC লিখে দিন আগত। The applicant as the appellant has preferred the accompanying appeal against a judgment and order dated 20/12/2023 passed by the learned session judge Jorhat in sessions case number 69 within brackets J-J bracket close comma stroke 2021. So stop. By the judgment and order dated 20/12/2021, the accused appellant has been convicted for the charge of murder under Section 302, Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of ₹5,500, with default stipulation. Full stop. We have perused the statements and averments made in paragraph 2 of the instant application, wherein the reasons for the delay of 9 days in preferring the accompanying appeal have been explained. To stop. Having gone through the same, we are of the considered view that the applicant appellant has been able to show, has explained the delay of 9 days, showing sufficient cause. Full stop. In any view of the matter, instead of the consideration of the accompanying appeal on merits, better serves the ends of justice. Mr. Das, learned additional public prosecutor, has submitted that he has no objection if the accompanying appeal is hard on merits. Full stop. Accordingly, the instant interlocutory application seeking condonation of delay of 9 days in preferring the accompanying appeal is allowed. Full stop. The office to register the accompanying appeal and thereafter to list it accordingly.
And deeply applies.
Item 19.
Net appeal.
May I appeal, Your Lordship? Lordship, this is an interlocutory application for condoning delay of
My lord, only one more, my lord, which I did not include, my lord. In the 313, my lord, the question, because my lord, the court has taken the conduct of the accused, my lord. So in the 313, my lord, that, my lord, plea of guilt at the stage of charge, my lord, was not, my lord, put on to the accused, my lord. This is the only additional, my lord. Because, my lord, the court has taken the conduct, my lord. The conduct of the accused, my lord, at the stage of plea, my lord, the plea, my lord, he initially pleaded guilty, my lord, and thereafter he retracted his statement in 313. However, through the extrajudicial confessions which he made in the police station, as well as before the PW8 Samuel Beg, who said that while returning home he met, my lord. So that part, my lord, in the judgment, my lord, the court has taken that part as conduct of the accused, my lord. So if that conduct is taken, my lord, for that only submission is that that question of guilty plea, my lord, which the trial court took, my lord, did not place before the accused at the stage of 313, my lord. This much, my lord.
Which part, where it is observed?
My lord, I'll just show your lordship, my lord, the relevant part in the judgment, my lord. Yes, my lord. It starts from line 2, my lord, from the above, my lord.
46.
46, my lord, judgment, my lord. It starts from this second line, my lord. He pleaded guilty. My lord, second, the accused retracted his admission. He pleaded guilty when the charge was framed and particular offense was read over and explained to him. He justified his conduct by stating that he killed his wife because he treated with cruelty by his wife and son, who never provided him with food, my lord. So, my lord, that part, my lord, the learned trial court has taken, my lord.
No, his conduct has been recorded.
Yes, my lord.
No finding has been
My
derived
lord,
from it.
That's correct, my lord. That's correct, my lord. That's correct, my lord. That's correct. That's
Court has
correct.
recorded what has
Yes, ma'am.
happened.
Yes, ma'am.
If court does not record, you will attack again. So court has not derived any finding from it. However, the evidence is contrary. He also retracted.
My lord, one judgment for extrajudicial confession, my lord. First, my lord, in the judgment, I'll take your lordship to para 7, my lord, internal page 4, my lord. This is with reference to, my lord, circumstantial evidence, my lord. And in para 7, my lord, internal page 4, my lord.
There are 7.
7, my lord.
That is Sarat Bidishan.
Yes, my lord, that golden 7 points, my lord, have been referred, my lord.
5,
Yes.
5.
5, my lord, sorry.
Conceal, 5.
Yes, 5. 5, my lord. I'm extremely sorry. My lord. And, my lord, thereafter, my lord, para 12, my lord.
So far, para 12 is okay.
Yes, my lord.
Para 12, then first few lines is okay.
Yes, my lord.
Up to so and so. But in the instant case,
My lord, this case goes against me, my lord. This case goes against me, my lord.
no, this case is not applicable.
Yes, my lord. This is not
Because
applicable.
this
Only
is
for
in the
the-
context of section 30.
Only, my lord, the first part of the judgment, which, my lord, in Sahadevan versus State of Tamil Nadu is there, my lord. That only I am trying to refer, my lord. Only that part, my lord.
Overall, shortening observation with section 30 is section 30. Okay, the lecture is precisely. But where is the extrajudicial confession here?
My lord, the
Extrajudicial confession is under which section?
section 25, my lord. 25 and 26, my lord.
24.
20.
As soon as there is presence of police, 25 and 26.
25.
26 will be applicable if magistrate is present.
Yes, my lord.
Here is a situation where police was present.
Present, my lord.
Law is also there. Police is present, even if he is not the investigating officer also, then also law is there. 25. Yes.
My lord. Deeply obliged.
You have received a written.
Lordship,
Sino-
yeah, I have received, my lord. Next page of his written argument. Or should I reply to the query made by this honorable court on the last
I
occasion?
asked you also to submit a written one. Yes, yes.
It was only to me, my lord.
Okay. Yes.
Plea of guilty is gone, my lord. Confession made in police station, whether it is admissible in evidence.
There were two parts to it.
Yes,
One is confession. Second one is the production of the dao.
thou, my
There
lord,
are two parts to
my
it.
lord.
Two incidents in the police station. One is his appearance with a dao. Second part is the confessional statement.
Before the witnesses who are not the police officers, but it was in the police station. Lordship, apart from that, there is one witness, PWA, Samuel Beg, before whom also extrajudicial confession was made, and that was not in the police station.
Who is he?
That is, your lordship.
Mystery.
I tried to see the original records. XD is written, my lord. XD, whether it's a ex-defense personnel.
Village Defense.
No, EXD likha ase.
VDP. It is VDP, Village Defense
No,
Party
no,
person.
charge sheet.
Come to PW8.
Lordship. But in the charge sheet, it's written as XD, my lord.
PW8 is not village. It's an employee.
Figured an employee, but
I have written here.
in page 78 of the paper book, Samuel Beg, hidden bracket X, EXD.
Mm-hmm.
78, my lord.
What is ESD?
Different, but try to locate the original. The type copy, my lord. So, lordship, whether the extrajudicial confession in the police station before anybody who is not a police officer, whether it is admissible in evidence, I have to rely on the constitution bench decision of court, Kartar Singh versus State of Punjab, my lord. Reported in 1994, 3 SCC, my lord.
PW8 has not said anything.
Lordship, it's there.
No, let us read
Let us read the evidence of PW8.
the cheap part.
Lordship. I know the accused person, he is my neighbor. I do not know the informant. I know that this is Minalini Orang, who was the wife of the accused. The alleged incident took place about 2 years back. On the day of occurrence at about 6:30 p.m., I was returning from the Jaipur police station to my something is there, yellow, so it's not complete. While I was heading to Jaipur police station, I received a phone call from Namrup police station that the accused had killed his wife. While I was returning home, I met the accused person along with a dao in his hand. And I asked him where he was going, to which he replied that he was going to Namru police station and asked me to accompany him to Namru police station. The next line. He also told me that he had killed his wife and so he wanted to go to the police station. That part remain unchallenged.
But he is a mystery.
Is a mystery. From where he had come. But all other witnesses said he accused person accompanied the village defense party personnel, my lord.
Okay.
And they rely on Qatar Singh, my lord. 1994 3 SSC 569. Last time they said.
Okay. You have supplied.
Para 383, my lord.
Para
383.
383.
Neither the Evidence Act 1872 nor the code nor his predecessor defined confession. This court in Palvinder Kaul versus State of Punjab ruled that a confession must be either admit in terms of the offense or at any rate subsequently all the facts which constitute the offense. An omission of a grave incriminating fact, even a conclusively incriminating fact, is not of itself a confession. A statement that contains self-exculpatory matter cannot amount to a confession. If the exculpatory statement is of some fact which is true, would negative the offense alleged to be confessed. Therefore, confession means an admission of certain facts which constitute an offense or substantially all the facts that constitute the offense made by a person charged with the offense which is the subject matter of the statement. In Pakala Narayana Swami versus King Emperor, an admission of a gravely incriminating fact, even a conclusively incriminating fact, is not by itself a confession. Example, an admission that the accused is the owner of and was in recent possession of the knife or revolver, which caused or date with no explanation of any other man's possession. Section 24 to 30 of the Evidence Act deal with probability or relevancy of a confession. A confession made by an accused person is irrelevant if it appears to the court to have been caused by inducement, promise, or threat, having a reference to the charge proceeding from a person in authority. By Section 25, there is an absolute ban at a trial against proof of a confession to a police officer, as against a person accused of any offense. The partial ban under Section 24 and total ban under Section 25 applied equally with Section 26, that no confession made to any person while the accused is in the custody of a police officer, unless it is made in the immediate presence of a magistrate, shall be proved as against such person. Section 27 makes an exception to Section 24, 25, and 26 and provides that when any fact is deposed to as discovered in consequence, that is leading to discovery, Your Lordship, consequence of information received from a person accused of any offense in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctively to the fact thereby discovered, may be proved. The provisions in Section 28 to 30 are not relevant for discussion. The fascicule of Section 24 to 30 aim to jealously protect the accused against becoming the victim of his own delusion or the mechanization of others to self-incriminate in crime. The confession, therefore, is not received with an assurance if its source be not omnisuspicious mosaic, above and free from remotest taint of suspicion. The mind of the accused before he makes a confession must be a state of perfect equanimity and must not have been operated upon by fear or hope or inducement. Hence, threat or promise or inducement held out to an accused makes the confession irrelevant and excludes it from consideration. A confession made to a police officer while the accused is in the custody or made before the became an accused is not provable against him or any proceeding in which he is charged to the commission of the said offense. Equally, a confession made by him while in the custody of the police officer to any person is also not provable in a proceeding to which he is charged with the commission of the offense unless it is made in the immediate presence of a magistrate. Police officer is inherently suspect of employing coercion or obtained confession. Therefore, the confession made to a police officer under Section 25 should totally be excluded from evidence. The reasons seem to be that the custody of police officer provides easy opportunities of coercion for extorting confession. Section 25 rests upon the principle that it is dangerous to depend upon a confession made to a police officer which cannot extricate itself from the suspicion that it might have been produced by the exercise of coercion or by enticement. The legislative policy and practical reality emphasize that a statement obtained while the accused in police custody truly be not the product of his free choice. So confession statement obtained by the law enforcement officer is inadmissible in evidence. So it goes against the prosecution, right? Since it was made in the custody or in the police station, although the evidence doesn't say so, that he was in the custody or not, my lord. I'll be relying on another judgment in that regard, my lord.
কিন্তু এই পিডব্লিউ এইটু তো পুলিশের ক্যারেক্টার হলো এটা আমি করি আছে রিপোর্ট পাই পুলিশে কেউ ফোন করে একটু তো মানুষ লাগিয়েছে এই পিডব্লিউ এইটু কোড অফ রুট ডিপি হয় এই বলে বলেছি পুলিশে বলে ভুলটা ফোন করি পুলিশে কেউ ফোন করি
ইনফর্মাৰ থাকে পুলিচৰ
Lordship, 1997, 1 SCC 272 para 19. The other reasoning based on section 26 of the evidence is also fallacious. It is true any confession made to a police officer is inadmissible under section 25 of the act, and that ban is further stretched through section 26 to the confession made to any other person also if the confession was then in police custody. Such custody need not necessarily be post-arrest custody. The word custody used in section 26 is to be understood in a pragmatic sense. If any accused is within the can of surveillance, the other day your lordship observed that, can of surveillance of the police during which his movements are restricted, then it can be regarded as custodial surveillance for the purpose of this section. If he makes any confession during that period to any person, he not a police officer, such confession would also be hashed within the ban contours outlined in section 26 of the Evidence Act. But I think para 20 goes in my favor if your lordship and Miss that
that is why we are trying to derive satisfaction about the status of PWA.
my lord, that is not clear.
Very clear. He is neither
To in the charge sheet, my lord, I could not find.
only one verified by prosecution because what is the reason for calling him over telephone? He is not a police officer.
My lord,
That this man had killed his wife. What is the reason?
he might be, but it's not on has not come on record. Whether he is a reputed man of the village or something like
He is
that. my
not
lord.
there. He was
I know.
going towards another police
I know.
station and he was called by police
Police
officer
officer,
and to inform that
lordship,
this man had killed his
my
wife.
lord.
Why?
Then he was he has taken the
And he met also
my lord,
accidentally
my lord,
the accused and took him.
lordship.
Normal man would have been, if the man had killed
You would have
his
scared
wife and walking on the road with
My
a
lord.
dove blasting,
my lord.
normal human conduct with better avoid him.
Avoid
Let
him.
us go as if
Lordship.
he has not seen him on the road.
My
My
lord.
lord, one such incident I overcame, my lord. In 1992, my lord, a man came in the Fancy Bazaar police station with a head in his hand, my lord.
Yes.
The entire area was, my lord, the people ran away, my lord.
Right. So the courage he has shown,
My lord.
this PWH, is not a normal human
My
conduct.
lord.
And taking that man in his pillion seat with the dove,
Courageous segment.
he is courageous man.
My lord.
He is not a police officer also.
Lordship. My lord. Para 20
Even
may
if
go in
some
my
courage
favor.
he
My
showed,
lord.
and he would have said, you drive the bike, I'm sitting the next side.
Billion. My lord.
Is it not?
Lordship. Lordship.
Or car, suppose car, okay, you drive the
My
car.
lord.
We see in the movies, the man who is apprehended,
My lord.
he is asked to drive the
My
car.
lord.
And the man who apprehends that person, he in the side seat or beside, pointing the pistol. But very courageous.
His identity is mysterious.
Identity is under cloud.
My lord. Lordship is correct.
And thereafter, my lord, the IO in his cross-examination says that accused came alone, my lord.
No, no, he came along.
That is there.
He was standing outside the police. He was waiting outside
He
the
was
police
dropped.
station.
He was dropped. But
was
the
dropped.
courage he has shown,
Yes, my lord.
Lordship.
courage he has shown,
My lord.
is quite,
Lordship.
and his, say, meeting with the accused after the call
My lord.
from the police station, these
Yes.
are not explained.
That is not explained.
You could have, say, one petrol party was there, police petrol party roaming around. Then police got information that this man might be there. You look at. Then they search
Then
2-3
that is-
persons, police personnel.
Lordship.
Yes, that
Right.
could have been understood.
My lord.
But here,
EXT এটুকু থাকবে
oh,
কিন্তু পিপিএ লেখা তার মানে এক্সাম আইডি
this is written by PP, EXD,
Oh.
examine.
Oh, lordship. Yes. Lordship, para 20.
Same. If it is not within.
My lord. Then it should be.
So even we cannot, who is he?
Well,
Why should he disclose to a stranger? He's a stranger otherwise.
But lordship. It has come up on record. He used to know the wife of the
Testimony.
accused. In his testimony, it has come up on record.
What?
He used to know the wife of the accused
Know the
person.
wife. And why he disclosed the accused that I had killed my wife? And he does not say that he knew the accused.
He doesn't say so.
He says that he does not know the informant, my lord. This son,
No,
my
he
lord.
doesn't know the informant, but he
Informant.
knows the
He
accused.
says that accused is my neighbor. I know the wife also, but I do not know the informant, my lord, the son of the accused, my lord.
Oh, he knows the accused person. He knows the accused person.
Start with the discussion, dictation. Any other point?
Have. That
Okay,
the-
resume at 2.
Lordship,
Resume
at two, my petition, which I have seized. This is the evidence of the lordship, the IO, my lord. And in the forensic laboratory report at page 76, lordship. Page 76. Para 2, page 76, description of articles. Number 1 is midda heavily rusted. Number 2, 2 numbers of airtight vial contains blood sample marked as exhibit B. there is not so and so cotton in the time of opening. Then here PM number 1100/15 has been mentioned, which will indicate that the blood sample has been collected from the deceased, my lord. Because the PM report, lordship, it's as regards the post-mortem autopsy conducted on the deceased, my lord. Lordship, and the evidence of the doctor, my lord, at page 19, serial number 6, here noting has been given. Blood samples collected and in clotted and NAF vials and handed over. Blood samples collected in clotted and NAF vials and handed over to escorting police as requested by the investigating officer in his forwarding letter. Lordship. And the next point is whether, Lordship, the LA's weapon was not shown to the expert, the doctor, my lord. Lordship, in the page 19 itself, in the opinion of the doctor, here it has been written, page 19, date was instantaneous following the neck injury. Lordship, page 19. Here, description of injuries are given. Then date was instantaneous following the neck injury sustained. All injuries were antemortem caused by sharp cutting heavy weapon and homicidal in nature. Approximate time since date is 24 to 30 hours. This time also tallies with the time which has been which is mentioned in the FIR. 24 to 36 hours. And your lordship, although in the cross-examination he has mentioned, he has deposed, LA's weapon was not shown to me, but nothing has been, no suggestion has been given, my lord, that the nature of injury, the injury received by the victim cannot be as a result of the weapon used by the accused person. And that it was heavily rusted. As in the this one, my lord, forensic science laboratory report, it was observed that your lordship, that the weapon is heavily rusted. But your lordship, one more thing, while collecting the material, while the seizure was made, my lord, the weapon, my lord, it was, lordship, may I take your lordship to the seizure list?
Page 55. 55.
55, my lord. Lordship will kindly note date and time of seizure 4:10:705 PM. Lordship is found it, my lord. So, description of seizure, a machete. The front part of the machete is little bit bent and pointed. The length of the so-and-so is 18 inch and inch so-and-so. A shade for keeping down. But in the, this one, my lord, forensic science laboratory report, FSL report at page 76. Your lordship will kindly note the examination which was done. It was done on 9/11/15. After more than 1 month, my lord. And can your lordship infer, since it was a bloodstained knife, so rust has taken place due to oxidation, although it has not come up on record, my lord. The last part was not there while seizure was made, whether in the forensic science laboratory report, and serial number one, number 3, meet the heavily rusted.
Page 55 is what date?
Page 55, my lord, 410.
14.
410. And your lordship, it is 911. The other day, your lordship has made the query that not showing weapon to the expert, whether it will vitiate the trial, my lord. What will be the effect, my lord? I'll take your lordship to one judgment to that effect.
No, not vitiate, but whether it
You effect
it
of,
is a
not effect of.
circumstantial evidence.
Yes.
It is a case of circumstantial evidence. So this is a
How will be the
one of the,
effect,
one of the links.
my lord?
Had it been a direct evidence,
My
case of direct evidence, production of weapons sometimes is not material. That is our tentative view. Yes.
Dada. 2017, 13 SCC 81. Sudhar Renukaiya and others versus State of Andhra Pradesh. I'll be relying on para 35 to 37. Para 35. One of the submission raised by the learned counsel for appellants that the doctor who appeared before the court was not shown the weapon to give his opinion as to whether the injuries could have been caused with such weapon or not. The learned counsel for the appellants relied on Cartari versus State of UP, wherein in para 26, following has been stated. It is the duty of the prosecution and no less of the court to see that the alleged weapon of the offences, if available, is shown to the medical witness and his opinion invited as to whether all or any of the injuries on the victim could be caused with that weapon. Failure to do so may sometimes cause aberration in the course of justice. In the present case, Dr. N. Subbarao, PW7, appeared before the court who had conducted the postmortem of Tirupati Rao. The doctor in his statement has stated that the injuries could be caused with battle axes and knives. PW18 has conducted the postmortem of Siva Sankara Rao. PW18 has stated that injuries noted in my postmortem can be caused by axes, battle axes, and knives. The eyewitnesses in their eyewitness account have stated that the accused used axe, knives, and sticks while attacking on deceased 1 and 2. The injuries noted in the postmortem of deceased 1 and 2 are injuries which can be caused by axe, knives, and sticks. Thus, there was no inconsistency with medical evidence and the ocular evidence. The date of both deceased 1 and 2 was homicidal in nature. A perusal of the statements of PW 17 and 18, the doctors who conducted the postmortem as well as PW 16, who gave evidence on injuries of PW 5, indicates that they were not shown the weapons by which injuries were caused. It is useful to refer to the external injuries noted by PW 17 on the dead body of Tirupati Rao. In the statement of PW 17 is stated as follows: the nature of injuries are given. Then para 37. Looking to the injuries as noticed by PW 17, it is clear that the cut injuries as noticed above could be by axe and knife as well as by battle as axe as opined by the doctor. The fact that the weapon was neither shown to the doctor nor in the cross-examination attention of the doctor was invited towards the weapon is not of much consequence in the facts of the present case, where there was clear medical evidence that injuries caused by knife, axe, and battle axe. It is not the contention before us that the injuries as noted by the doctors in the postmortem of deceased 1 and 2 could not have been caused by knives and axe. The submission has also been raised that it was put to the doctor that injuries by battle axe could be half moon. The doctor himself admitted in his report that he has not reported depth of the injury. middle of the injury, nor margins of the injuries have been noted. He has not described any injury as a half moon. The doctor himself has admitted that he has not described the shapes of the injuries, depth and middle of the injuries. The above medical evidence does not lead to the conclusion that injuries as noticed by the doctor could not have been caused by X, knives and battle X. The eyewitnesses, PW 1, 2, 3, and 5. My lord? Yes, my lord. The eyewitnesses PW 1, 2, 3, and 5 have clearly mentioned about weapons used by the accused, which is not in our case, my lord. Accounts in accordance with medical evidence. Thus, mere non-showing of the weapon to the doctors at the time of their deposition in the court is inconsequential, as in no matter weakens the prosecution case. Some discrepancies referred by the trial court in the statements of eyewitnesses were inconsequential. The eyewitnesses, after lapse of time, cannot give picture of perfect report of the injuries caused by each accused and the minor inconsistencies so and so. It is used, Lordship, in our case, no eyewitness is there.
Directly not quite applicable to the case in hand because it is a case of circumstantial evidence.
But I have to refer one thing, my lord. In the doctor's evidence, he has reflected the nature of injuries and there was no cross-examination to that effect, Lordship. And although the weapon was rusted, my lord, it was full of rust, that he was not put to cross-examination.
Why they will bring?
My lord.
Whether this can be caused by a Dow or not, why they will bring? Huh?
From the evidence of doctor, my lord, PW 6.
Sharp cutting weapon.
My lord, sharp cutting weapon.
Why they will indicate
Sharp
and
cutting heavy
pinpoint?
weapon.
Why they will pinpoint? Hit the axe on his own, in their own feet.
Is there, but since it has been mentioned in the opinion that it is by sharp cutting
Why
weapon,
defense should ask
my lord.
that whether this is possible? If they are not absolutely sure that whether these injuries are possible by a Dow, if he says yes, that is one more link.
But it was made by a sharp cutting weapon. It was made by a sharp.
Right.
Yes,
They kept silent there.
my lord, they kept silent.
They kept silent.
My lord.
Why they will ask that whether it
I
can
think
be
it will
caused
go
by
in
a
favor of
Dow?
us, my lord, prosecution.
Why they will ask that can these injuries be caused by a Dow?
Now,
They will ask.
my lord.
This is for the prosecution to establish everything.
So I think prosecution to that effect, because
Okay.
link in circumstance, my lord.
Your one circumstance is that confession.
My lord. First circumstance, the accused person.
Confession to you are stressing on
PW 8. And your first circumstances, he went with the Dow to the police station.
Okay, Dow. That is one.
Yes. Second one,
Alleged weapon not shown to the doctor will not
vitiate, it will
weaken
not
the
affect
prosecution case.
then the prosecution case.
And blood sample.
Blood sample matched with the
Group A.
yes.
Human blood. Dow and the diseased blood sample.
My lord.
So it was collected according to the procedure.
Then next, observe on the last opinion, lordship made a query. Moina was not examined. Moina. Lordship, Moina was cited as a witness in the charge sheet, my lord. I have gone through the records. Lordship, can we have a look, my lord? 2416, my lord. GR.
Order it.
2416. Moina Orangia is absent with steps. Order sheet was mark no correlating. Lordship, then summon was issued to Moina on 8/11/18. Then bailable warrant of rupees 500 issued to Moina. It was on 6/12/18. Summon on 8/11/18. Then issue bailable warrant 6/12/18. Then prosecution evidence was closed on 11/7/19.
Yes.
Then your lordship, as regards whether any of the neighbors have been examined
Hmm.
as a witness, because the case is that neighbor has not been examined, my lord.
Hmm.
Lordship, if your lordship goes to the sketch map, my lord.
Sketch map. Page.
Page 72.
72.
Page 72. Page 73. Here, lordship will kindly come to D. Index D, my lord, indicates the house of Jitu Hunwal.
Hmm.
Place of occurrence is A. Lordship, so in between residence of Dimbesar Hazarika who has not been examined, I know, Dimbesar. D, my lord, indicates the house of Jitu Hunwal. He was not examined, but his wife has been examined as PW5, my lord. Lordship may kindly see. Pallavi Sunwal, wife of Jitu Hunwal. Jitu Hunwal. Regarding non-examination of material witness, I want to place one judgment. 2001 666. Ani se nahi? 145. Para 19. Para 19. So is the case with a criticism leveled by the High Court on the prosecution case finding fault therewith for non-examination of independent witness. It is true that if a material witness who would unfold the genesis of the incident or an essential part of the prosecution case not convincingly brought to otherwise, or where there is a gap or infirmity in the prosecution case which could have been supplied or made good by examining a witness who, though available, is not examined, the prosecution case can be termed as suffering from a deficiency, and withholding of such a material witness would oblige the court to draw an adverse inference against the prosecution by holding that if the witness could have been examined, it would not have supported the prosecution case. On the other hand, if already overwhelming evidence is available, an examination of other witnesses would only be a repetition or duplication of the evidence already adduced. Non-examination of such other witnesses may not be material. In such a case, the court ought to scrutinize the worth of the evidence adduced. The court of facts must ask itself whether in the facts and circumstances of the case, it was necessary to examine such other witness, and if so, whether such witness was available to be examined and yet was being withheld from the court. If the answer be positive, then only a question of drawing an adverse inference may arise. If the witnesses already examined are reliable and the testimony coming from their mouth is unimpeachable, the court can safely act upon it and uninfluenced by the factum of non-examination of other witnesses. In the present case, we find that there are at least 5 witnesses whose lordship may not be necessary the other part. Here, lordship, my alternative submission is that can your lordship exercise the power under 311, my lord? Because he is the material witness. I've gone through 160, although I should not go into. One part he has seen the accused person in the vicinity, my lord, with a weapon in his hand.
It is not there that he has seen it.
With
He
a
is
weapon.
material because there is nothing as regards last seen.
There.
But that witness is also used to stay with his mother and father in the same house.
That witness,
Right.
but it has come from the mouth of PW1.
This is another brother.
Another brother.
He
that
said
accused- Yes.
that my brother so and my mother and my father used to stay together in the same house.
And-
And so far incident, I don't think it had occurred in night.
No, other factor, my lord. That the accused person used to threaten them, that they'll cut into pieces and go to the police station.
That is,
That is, can your lordship?
accused is not favorably disposed towards his wife
Yes,
and his son.
son.
That is an inference.
Yes.
That is a situation or circumstance. But whether threat has resulted,
The commission
an
of the crime,
act.
my lord.
that is what we are trying to
It has not
find
come
out
up
the
on
links.
record, my lord. It has not come up on record, but can your lordship take it as
When
a
the dead body was found.
lordship,
When the dead body was found.
my lord?
When the dead body
Oh,
was
when
found.
the dead body, it was gonna say 12:45.
And this man appeared in the police station
6:45.
after 6.
Yes.
So there is a gap of about 5 hours.
The last in theory will not come.
He was not seen.
But lordship, one thing from the this one sketch map, my lord, lordship, may kindly have a look at it once. Page 72. A is lordship visitable garden, wherein the dead body was found.
A.
Is the pure visitable garden, lordship. And my lord, accused in his 313, he has stated, my lord,
A.
my lord.
A.
Page 32 of my lord, 313 statement. I am innocent. I do not know about my wife's state. I was taking care of the cattle, although the place has not been mentioned. Lordship, a cattle at in the morning hours at around 12:45 will be
He will
outside,
not,
my
he
lord.
will not be with his cows in a vegetable garden.
Maybe, my
The
lord.
cows will eat up the
That
vegetables.
is there. One bit is vegetable he was growing, my lord. One vegetable is he was growing. That is not there. But sometimes, my lord, in order to
Vegetable
feed
garden, cows will eat up.
lordship,
So he will be away from the vegetable garden.
but he himself said, I was taking care of the cattle.
Cattle,
That is there. But in the grass field and all, the kettles are like generally like sheep,
one more question.
my lord.
Who is the informant?
PW1.
PW1, madam.
Now, he suppose in the chief, one is hit by, say, section 24, 25, 26. He said in his chief that he was present at the police station,
Yes.
right?
Yes.
When I was present, the accused came to the police station
Yeah, that time,
with a blood smeared in his hand,
my lord.
right? Come to the cross-examination,
Yes, ma'am.
second paragraph, second line. I also did not state before the IO that my father arrived at the police station with a smeared dao and confessed that he had cut my mother with the said dao.
My lord.
Right.
My lord.
This is completely opposite to what he had stated in the
Yes.
evidence in chief.
No, may I
So,
see?
it,
Your lordship, may I see?
yes,
LCR today.
paper book.
No,
Paper?
LCR. That CD 161.
So then he said one thing in the chief, completely says another thing in the cross.
Cross-examination.
Then it goes diametrically opposite. To bring him to his original position,
Right.
whether the prosecution could have taken the permission of the court to cross-examine him,
Oh, he should have been declared hostile and cross-examined.
to bring him to his original
My
position.
lord, my lord. Lordship.
That is not done.
Not done.
So he is not there.
Lordship,
Neither here nor there.
neither here nor there.
Regarding appearance of the accused
My lord.
with a dao
My lord,
in the police station,
my lord,
that is gone. So far PW1 is concerned.
concerned.
Now let us see who are the others. What did he say?
He also says in the same line, my lord.
Huh?
Page 12, my lord.
See,
Last line, my lord. Last about.
that is also gone.
I
Page
did not
12.
see. Then, my lord, PW3, page 13, my lord.
Hmm?
Page 13, PW3, last line, my lord, in the cross, page 13, last line.
See,
Hello.
gone. Gone with the wind.
My lord,
Secondly,
my lord.
these three witnesses who vouched that they were in the police station, and that at that point of time, the accused came with the dao. Though they, in their evidence, they have said, now they have said that in the cross part, they have made a U-turn,
My lord. But they were not declared hostile.
not declared,
Okay.
not to be. Now I have learned one more thing. Hostile is a concept of English law.
My lord,
There is nothing in the Indian law that one is hostile.
my lord. It is judgment I have come across on.
If there are two things, one is contradiction, and second part is that maybe because of some reason he has deviated from his original. So to take him back to his original version, that is also one of the purpose of granting permission to cross-examine to a party to its own witness, so that he can come back.
My lord,
So at that point of time,
my lord.
the duty of the prosecution should have been to take permission from the court and show his previous statement and to bring him back to his original.
My lord,
If he does not come, then mark it.
my lord,
Then IO.
my lord.
I think though very lengthy,
My lord.
but that is a law.
Procedure.
ঠিক আছে।
Learning is learning a lot, my lord. Trying to learn, my lord. Don't এইমাত্র যেটা ওনারা দিলেন। Silva মনে। Lordship, regarding the conduct,
Otherwise, the act was dastardly.
my lord. Lordship,
It was an dastardly act.
my lord.
The nature of injuries.
Lordship. And since he was a lordship man, he used to like kill pigs and all, my lord.
But legal, we have to travel the road
Within the ambit of law.
by the legal evidence.
My lord. His previous conduct, although it doesn't relate to the commission of the offense, but he used to threaten the victim as well as his son. The material witness was not before the court, and his subsequent conduct that he appeared before the police station with a weapon in his hand, smeared weapon with blood. smear, the weapon which is smeared with blood, my lord.
But that
That
was
can
not
be-
in the mouth of the person who was threatened.
That is
PW1.
not PW1, the
There-
other
it should have
witness who
been,
had not come before the
B2
court.
or who? B2 or who?
Rajendra.
Maina.
Maina is not before the court. So I was making the submission, my lord, can at this stage also your lordship may exercise power under 311 and call for his attendance, my lord. So that no guilty
Yeah, I know the photo. Can't affect it.
lordship.
Father, son, I don't think
Well,
what would be served.
It only want to take that.
But then thereafter they may not be aware of village people, my lord.
Son had turned back in his
But I have seen in 161 statement, it's there. He has
Right.
seen his father,
right.
my lord.
That is what we are discussing. That at that point of time, when he turned back on his own person in the cross,
My lord.
then his prosecution should have done
My lord.
certain things, which was not done.
Lordship, for the lapses of the prosecution, my lord,
Huh?
a guilty person should not remain unpunished, my lord.
But what is the corresponding parallel theory
Uh,
at the same time?
It's up to your lordship to take out the shape from the grain, my lord.
আজিতো সম্ভৱ নহ'ব এতিয়া দেখোন আপুনি কোনো We'll start, but not possible to complete today. We can roll over because we have single benches. My
Right.
brother has single benches.
So lordship, conduct
Which
later
paragraph?
judgment, will I say no, and is to,
It is not,
Conduct
may
that
not-
is not
may not be
necessary.
necessary.
It is a.
So lordship is acquitting him,
no, I'm not, we are not
my lord.
deciding it.
Right.
We will just note down the basic facts.
Yeah.
Today is not possible,
Lordship.
but we will not keep it pending. We will also like to have assistance while dictating.
My lord.
Because you have said many things. Tiwari has said many things.
well, last part, my lord, the Maina Orangia to the
One more.
to the independent witness Pallavi Sonwal, he only said that my lord,
You say when we dictate and the relevant part.
yes, my lord. PW
That is why I gave you 48 hours time to
yes, my lord.
prepare a synopsis, which you have missed. Don't ask more. We have given you time
Well,
to
yesterday, my lord.
prepare a synopsis, points by points. Then after that, don't travel beyond that. The present criminal appeal from jail under section 383, Code of Criminal Procedure 1973 is preferred by the accused appellant to assail a judgment and order dated 6/12/2019 passed by the learned session judge Dibrugarh in sessions case number 14/2016. Full stop. During the trials, commander accused appellant who was charged for the offense of Usury side as no?
Hmm?
Usury side.
Hmm.
And after the trial, comma, UXORICIDE. Check out usury side. UXORICIDE. Huh? And after the trial, comma, he has been found guilty for the offense of uxoricide and has been punished under section 302 IPC, Indian Penal Code. Full stop. By the by the judgment and order, comma, the accused appellant has been sentenced to undergo imprisonment for life and to pay a fine of rupees 1,000, comma, in default of payment of fine, comma, to undergo rigorous imprisonment for another month. Full stop. Para. It was the son of the accused, comma, PW1, who brought the allegation of uxoricide against the accused by appearing in the Namru police station at so-and-so PM. Oh, silent. On 4/10/2015. Full stop. On the basis of information given by PW1, Rajendra Urangia, comma, the officer in charge, Namru police station, registered an entry, comma, General Diary entry number 98, dated 4/10/2015, within bracket exhibit 9. Full stop. As per the said ZD entry, comma, the PW1 had interiorly informed that at around 10:30/11 AM on that day, comma, the accused chased his mother, comma, Mrinali Urangia, to the backyard of the house and dealt cut blows on several parts of her body. First off, due to severe injuries, comma, his mother, comma, Mrinali Urangia, died at the place of occurrence. Full stop. The ZD entry number 98 was followed by a written first information report from the informant desk PW1 Rajen Orangia, stating the similar facts. Full stop. On receipt of the written FIR, the officer in charge registered the same as Namrup Police Station, case number 151/2015 for the offense under section 302, IPC on 14/2015 and entrusted the investigation of the case to PW9, Deepak Putradhan, one sub-inspector of police attached to Namrup Police Station. First. Para. It is the case of the prosecution that the accused on the date of the incident itself, appeared in Namrup Police Station, at Namrup Police Station with a blood-stained dhow. And at the time of his appearance, a number of private persons, including the informant, including his informant son, were present in the police station. Full stop. The further case of the prosecution was that at the police station, the accused confessed before those witnesses and police personnel that he had cut his wife with a said dhow. Full stop. The investigation proceeded further with the examination of witnesses under section 164 CRPC and under section 161 CRPC and under section 164 CRPC. Full stop. As the place of occurrence was the house of the accused and the deceased, the IO proceeded to the place of occurrence on the date of the incident itself.
Yes, please.
Full stop. As the dead body was found lying, dead body of the deceased was found lying in a vegetable garden to the backward to the in the backside of the house of the accused and the deceased. Inquest was done where?
At the house, my lord. At the house.
The where is the inquest report?
The inquest report is at page 49, my lord.
Lordship, in the
Uh,
premises of the deceased.
The inquest on the dead body was held at the place of occurrence itself by the circle officer stroke executive magistrate. He was examined. Okay. Naharkotia Revenue Circle. Post op. After completion of inquest, an inquest report within bracket EXT 1 was prepared. Wherein, the prosecution witnesses, Rajendra Urangia, within bracket PW1, Tonkeshwar Gogoi, within bracket PW3, Mukut Gogoi, PW2, and Deepak Putradhar, PW9, signed as witnesses. In the inquest report, EXT1, it was reported that approximate date and time of death was 11 a.m. on 4/10/2015. Page 49.
Yes. Oh.
Full stop. The dead body was found covered with blood stains with grievous injuries over the cheek and neck, right hand, over the abdomen, over the neck, allegedly with sharp weapon. Full stop. After holding inquest, the dead body of the deceased was sent to the sent to the Assam Medical College and Hospital, AMCH, Dibrugarh, for post-mortem examination. Full stop. The post-mortem examination was performed at the AMCH on 5/10/2015. By PW
6.
6, Dr. Noyanmoni Pathak, Assistant Professor, Department of Forensic Medicine, AMCH. Full stop. Record he after the autopsy, comma PW 6 recording his findings, reporting his findings, comma prepared a postmortem examination report within bracket EXT 6. Full stop. In the PME report, comma PW 6, the autopsy doctor PW 6 reported that death was instantaneous following the neck injuries sustained. Full stop. It was opined that all injuries were antemortem and were caused by a sharp cutting heavy weapon. Full stop. That was said to be homicidal in nature, and the time since death was 24-36 hours approximately. Full stop. In the PME report EXT 6, comma, the following were recorded. The followings were recorded, page 50, 64, 64, A, A. A2A, 60. Para. In the PME report, EX7, 6, comma, it was further mentioned by the autopsy doctor PW6 that blood samples were collected in vials and handed over to police personnel, comma, as requested by the IO, within bracket PW 9. After collecting the blood samples in vials, comma, blood samples in vials, comma, the said sample was forwarded to the Directorate of Forensic Science Laboratory, Assam, Guwahati, within bracket FSL, for serological examination. Full stop. The alleged weapon of assault, comma, the dao, which was stated to have been seized in a police station on 4/10/2015, was also sent to the FSL for serological examination. Full stop. The Scientific Officer, Serology Division, FSL, comma, PW10, on receipt of the objects for had recorded in a report dated 22/11/2015, within bracket exhibit
Exhibit 11, my lord.
11, that the following objects, following articles were received for examination, page 76, B to B. Full stop. Avoid Exhibit 7, comma, PW 10 had also reported the results of examination as under same page, C to C. The IO, comma, had in the PW 9, had in the meantime produced 3 witnesses before court on 8/10/2015 for recording their statements under section 164 CRPC. And that said 3 prosecution witnesses were Rajendra Urangia, within bracket PW1, Mukut Gogoi, PW2, and Tonkeswar Gogoi, PW3. And their statements under section 164 CRPC were recorded on 8/5/2015.
8/10.
810.
8/10. Postal. Their statements within bracket লিখে দিব EXT4, EXT5, and EXT6. Postal. এটাতে the place of occurrence and prepared a sketch map of the PO within bracket exhibit 8. After completing investigation into the case, command number of police station case number so and so, the IO PW9 submitted a charge sheet under section 173(2) CRPC. White charge sheet number
128/2015. Page 77.
128/2015 on 31/12/2015, finding a prima facie case well established for the offense of murder under section 302 IPC against the accused. Full stop. In the charge sheet EXT 12, in the charge sheet EXT 12, comma, the IO cited listed 12 number of witnesses, 12 persons as witnesses, stating that they would bring the charge. They would adduce evidence in support of the charge, in support of the prosecution case. Full stop. Para. তার আগতে লিখিব এই যে সারেন্ডার যে stated to have surrendered. The accused was taken into custody on 4/10/2015 and thereafter, comma, was arrested. On submission of a charge sheet comma, the Court of Learned Judicial Magistrate First Class Dibrugarh secured the appearance of the accused from custody on 25/1/2016. Full stop. The accused was represented by a learned legal aid counsel on that day. Represented by who was represented by a legal aid counsel. Full stop. As the copies were ready, comma, the same were furnished to the accused as per the procedure laid down in section 207 CRPC. Full stop. As the offense under section 302 IPC is exclusively triable by the court of session, comma, the learned judicial magistrate first class Dibrugarh by an order of commitment dated 25/1/2016 committed the case records of ZR case number ZR2 must be 2769/2015 to the Court of Sessions by notifying of the learned public prosecutor and the superintendent of jail for necessary steps from their ends. Full stop. On appearance of the accused before the also on receipt of the case record of so and so, comma, the Court of Sessions registered the same as Sessions case number 14/2016. Full stop. The trial court was sought. On appearance of the accused before the learned trial court and after hearing, the learned public prosecutor and the learned defense counsel, comma, the learned trial court framed the following charge against the accused on 8/2/2016. Page 60 notice. When the charge was read over and explained to the accused, comma, in the order framing charge, comma, the learned trial court had recorded that when the charge was read over and explained to the accused, comma, the accused pleaded guilty to the act of killing his wife, stating that due to ill health, comma, he could not go to work. Full stop. Because of such situation, comma, his wife and his son used to mistreat him and did not provide him food. Full stop. It was as he had lost his temper on one day, comma, he assaulted his wife with a dao and killed her. Full stop. The accused stated before the court that nobody used to come to jail to meet him. Full stop. However, the learned trial court had further observed that considering the seriousness of the offense and severity of the punishment, comma, he deemed it fit not to exercise the discretion under section 229 CRPC. accepting the plea of guilty of the accused and to convict him at that stage. The discretion was used. The learned trial court had exercised the discretion to proceed with the trial. Just a line. During the course of the trial, comma, the prosecution side examined the 14 number of witnesses.
10, my lord.
What about this page 48 wrong? How more?
They say about SI Sushil Gogoi, but
Oh,
Huh?
yeah. One Rajendra.
Paper book or two?
Mukut,
10 years,
Nine.
Srirankeswar,
10.
10.
Vallabh,
Which one is correct?
7 Ojit Begu, 8 Samuel Bed, 9 SI, 10 Renu Borahende. Lordship 11 Sukramunda is not before us.
Not there. Pinto
11.
is not there.
That,
Sushil Gogoi is not
Oh,
there.
Lordship have to
why
check
the trial
ourselves.
court would record it wrongly?
Yung na, Ritu.
It was the first court.
সব দুবার আছে
Huh?
এই PW6 and PW13.
Something is wrong.
Noyanmoni twice, my lord.
Twice.
Dr.
Then
Noyanmoni?
that would reduce to 13.
30.
Yes,
But paper book says
she-
20.
Sukramunda and Pinto Munda,
Pinto Munda and Sushil Gogoi, my lord. These three
they are not there, not in the
not in the paper book, my lord.
But maybe
record.
No, deposition of PW 1 to 10, 5A, my lord. Only 10.
Okay.
Only 10.
Huh?
10, my lord.
no, in the paper, not in the paper book. The
No,
record.
no, in
You
the
go to the
record.
record, original record.
Yes, up to 10, my lord. Up to 10. Photo dekhav na?
Hmm? In the judgment, any reference?
No reference, my lord.
11, 12, 13,
No
14?
reference. No reference.
Then order sheets. Check order sheet.
And in the third set, whether they were cited.
No.
No,
In the charge sheet also, those are not cited witness, my lord.
Where from Sukramunda, Pintu Munda come?
Page
Otherwise,
78, my lord. Because my lord, Pabitra circle officer did not turn up and my lord, Maina Urangia, page 78.
uh-huh.
Page 78, my lord, the charge sheet shows witness only 12, my lord. Wherein, my lord,
No,
witness number 2.
I was wondering whether it is a creation of copy paste.
Maybe.
that may be.
Up to 10.
Because, my lord, in
Paper book or file.
GD entry number 98 also, lordship would find the time written as 8:30, my lord, of the GD entry and FIR filed at 6:30.
We are seeing page 48. We are considering on page 48.
Okay.
Why you are anytime going to the merit of the case? Last PW 3 niki. PW 3 দেখাইছে recorder. Paper book পড়া লিখি দিব, huh? And exhibited 12th number of documents. Therefore, page 48. The prosecution side also exhibited a material exhibit, MATEXT1, down. Full stop. After hearing the learned counsel for the parties and after appreciation of the evidence stock materials on record, the learned trial court has delivered the judgment and order of conviction and sentence, as already mentioned here in the book. We have heard Mr. A. Tiwari, learned amicus curiae for the accused appellant, and MSB Bhuya, learned senior counsel and additional public prosecutor, assisted by MS Ardas, learned counsel for the respondent state.
Okay.
We'll put it in the next week. Today is Friday. Monday is holiday. Already posted 1 or 2 cases on Monday and Tuesday. Maybe on Wednesday. Hard, in part. Hard in part. Hard is the beginning. So that's part.
Friday, Wednesday. Date will be
Madam, eventually you please go through the record again,
Lordship.
from
Whether-
where the four witnesses come.
Yes.
All Munda. I don't think Munda is the way. Telling. Urangia. Maybe.
Lordship. I
We
will
find out.
Well,
May it please your lordship. Lordship, this matter pertains to promotion to the post of UDA in the establishment of the Chief Judicial Magistrate Ojai. My lord, under the ministerial rules of 87, my lord, promotion to the post of UDA is to be governed by the principle of seniority cum merit, my lord. In this case, my lord, when the promotional exercise was undertaken, my lord, an interview was held where they prescribed a threshold of a minimum qualifying mark of 30. Whoever got more than 30, from them the senior most were promoted, my lord. So in the seniority list, my lord, I was number 2. Number 1 has subsequently retired. Now number 1 and number 2 were bypassed, and number 3 and number 4 were promoted, my lord. On the
Where is
basis of
that?
the mark obtained in the interview, my lord.
You are Kobita.
Kavita Bora, my lord.
Where is your seniority list?
Seniority, my lord, will find it. Page 46 is the resolution, my lord. Page
41.
Page
41 is the, my lord, gradation list starts from 39. Relevant part at 41, my lord.
39.
39, my lord.
39.
Relevant
Your
part, my lord, at 41.
promotion from the
Post of LD, copyist, typist to the post of UD, my lord. UD assistant.
Okay.
41, my lord, will find my name at number 4, my lord.
Page 41.
1.
Where is the petitioner?
Petitioner number 4, my lord, Kobita Bora. Number 1 and number 3 were earlier, this is the gradation list of 22. They were earlier promoted, my lord. So 2, 4, 5 and 6 were there, my lord.
Petition number 1.
Petitioner is, my lord, number 4.
No. Seal number 1.
CL number 1 already promoted in 2023, my lord.
Promoted.
Number 3 also promoted, my lord. 2 and 4 were remaining, my lord. 2, 4, 5 and 6.
3 promoted.
Promoted, my lord.
So who were in the contention?
2, 4, 5, 6, 7 and 8.
2, 4, 5, 6, 7 and 8.
Now, my lord will kindly come to page 49, my lord. These were the candidates, my lord, who were called for the interview, my lord. I am at number 2, my lord. 1 Charu Devi, 2 Kavita Bora, 3, 4, 5, 6, my lord. So finally, my lord will find the result, my lord, at page mark sheet, my lord, at page 52.
Page 52.
Here, my lord, 1 and 2, they did not qualify because they prescribed a minimum threshold of 30, my lord. I got 29.33, my lord.
What is the criteria?
Criteria, my lord. Rule 6.3, ministerial rules, my lord. And I have a copy of the rules, my lord. Page 5, my lord.
upper division assistant, my lord, by promotion on the basis of seniority cum merit, my lord. And does not prescribe, my lord, any other mode of conducting any examination or any viva, my lord. And even in the resolution which was taken by the respondent authorities, my lord will find it at page 46. Here also they have resolved, my lord, clause A, my lord. The board resolves to adopt following mode of selections in respect of UD assistant. Selection shall be made on the basis of seniority cum merit, my lord.
Mr. Das, there is another issue of computer types also.
Yes. Now all are in the same copies,
But
typists.
some repetitions are pending.
Yes, with regard to that notification that has been challenged by which my lord, all are assimilated into one category. That will come up for
Who
hearing.
has been promoted?
Uh,
Who has been promoted now?
Anupam Paul and Anirban Bose, page
They were-
52.
Computer typist, my lord. Two vacancies, my lord. 1 and 2 were bypassed, 3 and 4, my lord. One has subsequent. My lord, this took. Yes, my subject to outcome, my lord. Because this took place, my lord, within the span of 2 days, my lord. 22nd, my lord, the results were declared. On 24th, appointments were given, my lord.
These are
That is
promotions.
proposed, my lord. Yes, my
My
lord.
lord, this seniority cum merit is concerned. My lord, it is settled that it is like fulfilling of a minimum merit and thereafter seniority. So far as I have seen the minutes, even if person scored 41.83, they were not appointed, page 52. The criteria seniority cum merit has been purely followed here. Minimum merit has to be ascertained. You cannot claim as a matter of a right, matter of right by virtue of seniority cum merit. So there is nothing wrong. Lordship will issue notice, that is my submission.
Yes.
So seniority cum merit has been followed. Anupam Paul 39, Anirban Bose 41. Anupam Paul is senior, Anirban Bose is next to him. So even though they got 39 and 41, they were promoted by virtue of their seniority. 41.83, 40.33 left out, my lord.
What is the minimum benchmark?
Minimum, my lord, they have created a minimum, the selection committee has created minimum benchmark 30
Where
for
is that?
ascertaining the minimum merit.
Where is that?
My lord will
you
find that at-
find
In the
page
resolution, my lord.
48. The resolution start from page 47, resolution number 1. And the criteria your lordship will find page 48. So there is nothing wrong in ascertaining the minimum merit, my lord, in this manner. You cannot claim that merely because I am senior, I'll get the promotion.
Two, if I may reply, my lord. Two issues, my lord. First of all, my lord, when they issued the notification calling us for their interview, my lord, the fact that they have prescribed a minimum threshold of 30, my lord will see at page 49, that has not been disclosed. We were kept in the dark about that fact, my lord, that there is a minimum threshold of 30. Subsequently, in the same resolution, which has been now cited by my learned friend, which gives a 50 mark, my lord, there is a breakage of 50 marks, my lord, 10, 10, 10, 10, 10. Now, what is the criteria which has been followed in awarding this mark? Because there's a clear breakage of marks, my lord. That has not been disclosed, my lord. And when, my lord, the question of minimum.
What is this criteria? Page 48.
48. My lord, this is to ascertain the minimum merit, in my understanding, my lord.
That this is
My lord, somehow this way or that way, a person, the minimum merit of the person has to be determined while following seniority cum merit. So far as my knowledge goes. And for that purpose, an exercise is done. And
In that case, my lord, at least
I can produce the records, my lord. My friend wants the breakup, I can produce whatever is there. But prima facie, my lord, seniority cum merit, if you want to, if we need to have a merit, minimum merit.
there appears to be some elements of arbitrariness. This
This-
is now I have seen for the first time. Now I don't know whether it is a
This is not the practice.
it is a norm.
My lord.
This 50 mark.
Yes.
This breakup.
Yes, my lord.
Maybe service jurisprudence has advanced. I don't.
Even otherwise
This,
also,
this is element of arbitrariness
if we skip,
seem to be there, marks on personality. Who will decide? Who will decide? All this reading and understanding skill will decide.
the
This
committee,
year in the same mark for 5 years normally is the for the purpose of deciding the merit element in a service come seniority come merit criteria. These are elements of there is presence of arbitrariness. I can understand qualification. Okay. This should be in preference criteria. Well, supporting okay, but I have a feeling that this marks on personality, reading and understanding skill. Where from you are gauging these skills?
perhaps I'll just consult the records, Millard. Perhaps some test or something. Yes. No, for
I have seen it for the first time. Maybe service jurisprudence has advanced on the seniority of merit criteria to a different extent. I don't know. But otherwise, having a look,
Lordship.
my understanding was that ACR of previous 5 years
Yes.
takes care of the
Merit.
merit criteria. When seniority come merit, yes, very good, outstanding, very good, good, average, below 5. And you have your notification also. What is to be given out of 30? Outstanding 6, very good 5, like that. That is the set. Then if there is more than it, I don't know. Maybe you'll be able to apprise.
Millard, if I get the records,
Because
Millard.
in other cases which we have dealt
Lordship.
earlier, disposed of,
Hmm.
we did not come across such.
In one
criteria.
or two cases, Millard, I found this following this criteria that they hold a written test just to ascertain this. Millard, I'm not very sure whether in all the district courts this is followed or not. But one or two cases I have also found this, Millard. They hold some kind of test to ascertain the minimum merit in the seniority cum merit criteria, Millard. One or two cases I have found. Not in all the district courts, Millard. That's for sure.
We have verified also, my lord.
Yes.
Maybe,
Right.
but that is what I have said, that service jurisprudence may have advanced
Yes.
to an extent that to decide seniority also or merit also, minimum benchmark, these are required. Maybe.
Minimum benchmark, I have also some reservation. This 30 marks qualifying mark, that I have also some
Because
reservation.
it has gone beyond the High Court notification.
True.
It has
This
gone
30
beyond,
marks I
maybe there is something more.
No new notification I have come across, but qualifying marks, but to keep someone at 30, I have some reservation in that. But that is not the
30 was as per the notification. As per the notification, total 30
Yes.
and minimum benchmark was 18,
Yes,
if I remember correctly.
Lordship.
So far, on the merit
Merit.
element in a seniority cum merit,
Yes.
as per the said notification, the criteria perhaps, I don't know for High Court employees or
Yes.
other employees, but
For
minimum was 18
yes.
and no other parameters
In fact,
were included there.
true, my lord.
It was purely on ACR.
Purely on ACR. Yes.
So far as merit minimum benchmark is concerned.
Minimum benchmark is concerned.
Thereafter, interview may take place. I don't know. But ultimately, it is if someone meets the minimum benchmark, then seniority takes precedence. There is no question of any element of merit.
That minimum is there.
Benchmark,
Yes.
that has to be
Process the
there.
seniority.
Yes. This is
This is the correct-
LDA to UDA. I could have understood. It is a merit come seniority.
Then it's
Then
totally
it is
different.
quite all right.
Then it's totally different.
This criteria is to quite all right.
Yes,
But I have some.
yes. But I have reservation with this 30 qualifying marks, Miller, because I think this was not needed.
Hard. Huh? Needed.
Not needed.
Not needed, Miller. Qualifying 30 marks is not required.
Yes,
Please.
Nawaz,
Learned Council for the petitioners. And Mr. H. K. Das,
Respondent.
Respondent number
Learned
two-
Standing Council,
2, 3, 4.
Guwahati High Court, for the respondent number 2, 3, and 4. The two petitioners,
No, one petitioner, my lord. One had
petitioner,
senior most retired, my lord.
the petitioner is presently serving as
Copies, my lord.
as a copyist in the establishment of the Chief Judicial Magistrate,
Hojai.
Hojai. Posto. It is the case of the petitioner that the post of copyist is a feeder post for promotion to the post of upper division assistant under the Assam Chief Judicial Magistrates Establishment within bracket Ministerial Service Rules 1987. Within bracket the rules 1987. Full stop. As per Rule 6(3) of the rules 1987, comma, the promotion to the post of lower division assistant. The criteria for promotion to the post of lower division assistant is seniority cum merit. Full stop. It is a further case of the petitioner that when two vacancies in the post of LDA arose in the establishment of the
I'm sorry, my lord, UDA.
huh?
UDA, my lord.
UD. In the establishment of the respondent number 3, comma, an exercise was undertaken on the to fill up the said two vacancies. By considering 6 number of candidates in the feeder cadre, postcode. The selection board constituted for the purpose held an interview on 22/01/2024 and allotted marks to the candidates interviewed. Full stop. After completion of the process, comma, an order dated 22/01/2024, within bracket annex 12, has been passed, whereby the respondent number 5 and the respondent number 6 have been selected by the selection board on seniority cum merit basis for the seat to vacant post of upper division assistants. Post of. Aggrieved thereby, comma, the petitioner has approached this court by the instant writ petition. Full stop. It is the contention of the petitioner that the petitioner in the gradation list published
31/12/2022.
31/12/2022 of employees who are in the feeder cadre for promotion, comma, the position of the petition was before the respondent number 5 and the respondent number 6. Full stop. It is the further contention of petitioner that the selection board had adopted a criteria, comma, alien to the seniority cum merit criteria as contemplated in the rules 1987. Full stop. Mr. Das learned standing also, GHC, has submitted that he would need instructions to traverse the contentions raised by the petitioner in this instant writ petition. Full stop. Para. Issue notice returnable in 4 weeks as so and so appeared accepted. The learned counsel for the petitioner shall furnish a copy of the petition along with annexes to the learned senior government advocate Assam for service of notice upon the respondent number 1 within 3 working days. Post up. The petitioner shall take steps for service of notice upon the respondent number 5 and the respondent number 6 by registered post OD within 3 working days. Where having regard to the contention raised, comma, it is observed that the matter of promotion given to the respondent number 5 and the respondent number 6 by the order dated 22/01/2024 will be subject to the outcome of the writ petition.
Extra copy. I'm deeply obliged, madam.
Much obliged.
May it please your lordship.
Counter is not filed.
I have received a comment, madam,
How much?
yesterday. 3 weeks.
Till then, lordship, the interview may be continued.
Heard Mr. DJ Kapil and counsel for the petition and Mr. G. Boishal and standing counsel. Guwahati High Court for all the respondents. Post up. Mr. Boishal has submitted that instructions have been received to file the counter affidavit and has thus paid for 3 weeks' time to file such counter affidavit. Full stop. The prayer is allowed to raise the case after 3 weeks. The interim order passed earlier shall continue till the next date of this.
Obliged.